On the morning docket, you had continued Kareem Williams from, I believe it was last week, the out of custody pretrial, because he wasn't able to get to Panama City.
Okay. Come on up, Mr. Williams. Okay.
Judge, he had been offered a pretrial intervention. We had supplied that to him, and I'm not sure what his intentions are. All right.
You understand a pretrial intervention is an agreement you have with the state that's basically supervised by the probation and parole, and then the case is dismissed if you successfully complete the that term.
Could you repeat it?
Pretrial intervention is a program that's offered by the state, and it's supervised by the Florida Department of Corrections. It's like probation, but it's not probation. It's an agreement that if you successfully complete the pretrial intervention, the state drops the charges against you.
I spoke with my public defender, and he gave me the terms and the things that I have to do, and I didn't agree with him.
Okay.
And I don't understand.
Sir?
I don't understand. So, like, the charges would be dropped.
If you successfully,
If you did all those terms,
you have to abide by those terms and conditions, and the case would be dropped.
Could I ask a couple questions? Shortly, I didn't really get all I really spoke over. What we went over was the terms.
we had several phone conferences that were scheduled.
Yeah, we missed a lot due to the time difference.
Sir?
I said, but we missed a lot due to the time difference.
He was on Eastern time, and he would call an hour late.
I mean, a pretrial intervention is about as good as it gets. If
All right, guys, buckle up, because we're kicking things off with Kareem Williams. He's standing before the judge, staring at the golden ticket of pretrial intervention. Do the program and walk away charge-free. But instead of grabbing the lifeline, Kareem hesitates, tripping over time zones and terms he doesn't like. The judge spells it out plain: take it or face trial. Yet Kareem digs in, leaving us shaking our heads.
you can take it or not take it, are we ready to set it for trial?
Yes, sir.
I don't want to do trial.
Well, then Mr. Meredith has done exactly what he's supposed to do for you. He's got the very best deal worked out for you. If you abide by the terms and conditions of the pretrial intervention, the state will dismiss the charges.
So the charges are brought upon me are by the state.
Well, who do you think brought them?
I thought I had a party.
Huh?
I thought it was an injured party.
The injured party, aren't they dope cases?
What is the jurisdiction of it? Is it criminal or
I
civil?
don't think you're near as smart as you think you are. I can
I'm just
tell,
asking
I can
questions.
tell you're not. Your possession of a controlled substance, giving false name, causing adverse effect. I guess there could be a victim on that. And resisting officer without violence. So, I don't know anything about the case, but it looks like you might have got a false, gave somebody else's name.
You just told me that the state was the.
The state's the only person who can charge you. Nobody else can charge you. It's the
Oh.
state. The victims can't charge you. They're just the alleged victims. They can't charge you. They can't do anything except make a complaint. But you've got offered a pretrial intervention. If you do the pretrial intervention, the state will drop the charges against you. If you don't meet the pretrial intervention, you come back to court and you start your defense again.
I don't wish to argue the facts.
Let's set it for trial.
Yes, sir.
Let's set it for May 5th at 8. Let's set it for June. What was that June date?
Now watch closely, because here's where Kareem slips into classic sovereign citizen logic. He's asking if there's even a victim and who is jurisdiction, as though the system is optional. The judge snaps back. It's the state pressing charges, not individuals. Simple. But Kareem insists on circling confusion while the court lines up a trial date. Opportunity wasted, lesson ignored.
June 2nd at 8:30, and it will be May 23rd at 1:30 for trial management. And if you change your mind and want to enter the pretrial intervention, you probably need to discuss that with Mr. Meredith. But remember, he's on Eastern Standard Time. Okay?
I'm on
He's
Central.
Central Standard Time. You're on Eastern Standard Time.
This is case number 23-1659, 92. This is LBNB Funding LLC versus Jennifer Moore. The matter is before the court, settling for a motion hearing. Counsel, your appearance regarding this matter, please, sir.
Thank you, Judge. May it please court, I am attorney Richard Grusin, and my bond number is 35222, and I am the attorney for the plaintiff.
All right. It appears to me that there is a motion to set aside the default judgment that was entered in this matter. That motion was filed on January the 29th. All right. And do I have Jennifer Moore on the Zoom?
Yes, good morning, Your Honor.
All right. Thank you, Ms. Moore. Good morning to you, ma'am. All right. And it appears that the plaintiff is moving. That's right there. Yeah. Well, no, I see the plaintiff's answer to the defendant's motion to set aside the default judgment. Now, tell me why you believe that the default judgment should be set aside in this matter.
Well, to start off, I did call LVNV Funding when I checked my credit score, and that's how they were able to reach out to me. They were sending information to a different address, and according to Site 15 USCA 1692-, I asked for a debt validation. I asked for the payment of history. I asked for a signature of contract with me and the creditor. I also asked for if there was any insurance claim filed, as well as the title of chain of this contract. And I didn't receive any answer. Next thing I know, my mom was dealing with pancreatic cancer. I'm an essential worker. I have 2 disabled kids. So when they were sending out these motions and so on, I was unable to receive them because I wasn't getting the mail and so on. So, and I reached out to the creditor, and they said that they gave my account to Midland. I have since resolved the issue with Midland, and it is paid. I then reached out to LV. They failed to give me all my information document needed, and now we're here. So I apologize for not appearing in court when I was going through my difficult times in life, but I am here now.
Moving on, we meet Jennifer, or as she styles herself, House of Jennifer. She's late to the game, begging to overturn a default judgment after missing court dates. Her excuse? Family struggles and confusion over who owned her debt. But instead of clear evidence, she piles on sovereign citizen jargon, contract signatures, validation demands. The court listens, but the argument's built on sand.
All right. Thank you. Thank you, ma'am. Mr. Rusin, your response, I do see you file a written response, sir.
I'm not sure how to respond to a lot of that stuff, Judge. I can tell you that I have been retained as the lawyer for LBNB Funding since November of 2023. I'm looking through my file right now, including electronic notes. I am all the way up to October of 2024. And of course, the register of action notes that judgment entered in this matter on June 12th of 2024, based on personal service of the summons and complaint. As I continue at the moment to keep scrolling down, I see that the first time defendant called my office, according to my staff, is December 5 of 2024. December 5 of 2024. And then, again, under 1692 of the act that she's citing, validation of debt notices go out within the first 30 days of the initial demand. Defendant was way beyond that period. Judgment was already taken against her. And so the case continued. I can see that she filed an objection to the wage garnishment in this matter back in December of 24. And then the matter was argued on January 8th, Judge, on your record. She told you at that time, to my appearance attorney, that according to her argument, that, quote, The matter that's before Your Honor was with Midland Funding, which she paid. You indicated that she was attempting to attack the underlying judgment. The balance was given to defendant at that time of January 9th. So basically, as we've gone on now, Judge, by virtue of garnishment, there's about $89 I see statutorily owed on this case. I was frankly prepared to file a satisfaction of judgment. Oh, I see also, to perfect the record, that January 23rd,
I can't hear.
this case was argued. I'm not done, madam. The case was continued to press, and so here we are now with good.
Mr. Rosen, I'm stopping you. I'm stopping you because your device is breaking up, and that's what the defendant was saying, is that she's not able to hear you. It was going real smooth there until about that last minute, and something went miserably bad, and so you're going in and out. You indicated the last thing that was clearly heard was that you prepare to offer a satisfaction of judgment. You said only about $89 or so was owed.
But exactly. Yeah, that's right.
After that, we weren't able to hear you very clearly.
Here comes the creditor's attorney, cutting through the fog. He lays it down. Jennifer's debt came straight from Credit One to LBNB Funding, no Midland involved. If she paid Midland, she paid the wrong people. By now, the balance is almost gone, just a handful of dollars left, and he's ready to file satisfaction of judgment. The law is steady. The facts are clear. Jennifer's narrative crumbles under the weight of reality.
Okay, so Judge, there's less than $100 owed now, which was addressed back on the previous hearing in January. Just a second, I was there. You adjourned the hearing to the present date. Yes, January 24th, we were last on your record. Now the judgment is pretty well paid, and I am prepared at the moment, well, I'm prepared now, to file a satisfaction of judgment because it's all paid. I have no idea what Ben is otherwise arguing about, but on that I rest.
Well, for the rest of your honor.
Excuse me. Let me ask you, Mr. Rosen, obviously, there's something about Midland here. Have you seen anything that shows a debt satisfaction regarding any claim, any indebtedness with Midland?
Yes, that's what you need to do today.
Yeah, but I'm saying, have you seen anything along those lines?
This case is never with Midland Funding. I don't represent Midland Funding.
Okay, well, but you understand my question, right? Have you seen anything from Midland as a part of your file or anything that shows that this debt is satisfied?
Well, I'm going to satisfy it now, but if she's saying that she paid this bill through Midland Funding, this case is never with Midland Funding. This is more or less a first assignment from Credit One Bank to LBNB Funding, and that's it. This is not a case that went passed around the room like last year's potato chips. It's a one-time assignment from Credit One Bank to Midland to LBNB Funding. Midland Funding is not involved in this, and I do not represent Midland Funding in my office. On that, I rest.
I'm back to you this morning.
May I?
Yeah.
Thank you, Your Honor. And I agree with you. I also reached out to the original creditors. That's why we're here now, Mr. Rosen, because I did reach out to.
That's Rusin, ma'am. Rusin.
Oh, many apologies, Mr. Rusin, Attorney Rusin. I reached out to the original creditors, and they stated that my account was given to Midland, and that's where my account's set. Now, however you guys transact the assignments on collectors end, that's not my specialty. That's not my profession. However, that debt was, and as of this debt, my checks are not getting garnished, so it's paid in full. There is no remaining of $89 because it has already been taken out. And moving forward, for the record, Your Honor, if they can just, what I've been requesting and asking is the debt of validation. I'm asking for the payment history. I am asking for a signed copy of the signature where the with the contract of my signature. I'm asking if there was any insurance claims. These are my rights to ask. You guys, LVNV, should provide me this information. Now, the debt has been paid, but for the record, Your Honor, for my records, may I have this information?
All right. All right. Thank you, ma'am. The central issue addressed by the motion in this matter is a motion to try to set aside a judgment that was entered by default in this matter. There would have to be a showing of good cause and a meritorious defense. And I've read the motion. I've listened to the arguments. I don't see a showing of any meritorious defense to the claim. Moreover, obviously, sickness would constitute some basis for showing a good cause, but you have to have both items, good cause and a meritorious defense. The whole notion of backtracking in this case prior to the entry of the judgment and demanding documentation of the debt and so on and so forth. None of that is relevant to the motion to set aside the default judgment. It's just the default judgment, you have to address the issue of whether or not there's a meritorious defense and an affidavit to support that. And there simply isn't. And for that reason, after further reviewing this matter, for that reason, I don't see a basis for setting the judgment aside in this matter. It does appear that the defendant is entitled to a satisfaction in this matter, and that should be forthcoming from the plaintiff. If it's not, then the defendant may present to the court an application for satisfaction. I saw that there was something presented with the motion, but that was not in the form that is required post satisfaction of the judgment. That was a form addressing the satisfaction of a judgment in relationship to Midland, and Midland is not the plaintiff before this court. So that's my determination. The motion is denied. Again, it seems that this is at the end of the road, and I look forward to receiving a satisfaction judgment to close this out. I do wish both sides well. Good day to you.
The judge closes a curtain with finality. To undo a default, you need both good cause and a solid defense. Jennifer had family struggles, sure, but no real defense to the debt. Motion denied. The judgment stands, though it's nearly paid off and will soon be satisfied. And there it is. Folks, the system works by rules, not by wishful thinking. If you like this breakdown, hit that like button, subscribe, and we'll see you in the next video.